Ameni. Sizisintha kantu ati Mulungu akuti sizisintha kantu. Zinthu izozo sizingasinthe kantu. Panayenera wawina nduyu mmene amanenera kuti akokera ko ndi asilikali. Ani chifukwa chake Mulungu anandifunsa panja kale oti asilikali apita akamugwira kwa mukoka kwazililira komweko ndiye pazakhala mwazi nkhani inalipo ndi anga timene ma social media ndiye Mulungu anati tapita ukafotokoze palibe chitasinthe ndiye kuti amati atawine ndi wakuti amachula chakwera ndi amene atawine ena amachula chilima ndi amene atauze kuti ndi amene awina uyuyo akanira komweko sizingasinthe chani zinthuzo sizisintha kanthu pano tikulikirirabe chifukwa tili ku phase 2 santi yena so apitaso kwina adionjo Malawi kuzwa chimene uli mumaziwa chimanga chija chimene osati chokazinga chiwaya yayi koma pali chimanga china chimene chimaika chikusa kapena moto ameni ndiye kumachita kuchita pa manja kumachiponya pati ndiye kumachigwedeza ndi kantengo timati kubulisa kutani tili tonse ndiyako mkono tonse ndiyako muzi ameni timati kubulisa ndiyo kamabulisa chimanga chimene umachita sumachichosapo ndi mtengo ukwenda kugwira ndi chani ukagwira ndi manja umaponya mbale chimapita kuti aleluya ndi pamene ali Malawi ndi pamene ali pasenta ake iti chimanga chake chobulisa ukwendera ndi mtengo chikupya ukangochedwa chipherera palipo ufunika uchita changu komopya mutiwe iwe ukachitolera mkamwamu upyasa mutiweyo ingotafuna umeze ameni mpamene Malawi ali mondimba inyoma mondimba bwino ino amene tabatira kumuzi bwino ifeyo tikuziziwa tikuziziwa so fusolanga ndi chani chimene tachita kuchokera pamene pacha ndi chani chimene taphunzira kuchokera pamene pacha chifukwa mikangano ndi imeneyi zonse ndi zimenezi yasala mikangano imene ikubwera papa ndi ya malamulo ameni malamulo ene ndikwaziwa inu mukwaziwa ndiye sopano tiye tikumane sopano wina akwata miruzira waku wina akwata niso chifukwa chake Mulungu akuti timange Malawi titaganiza mphawi wathu titaganiza mavuto athu koma tikumbukire mavuto ana aziko Malawi so nyengo ikubwera uku ndi imeneyi koma Malawi ali ngati munthu amene akubulisa chimanga apya manja akangochedwa kuopa kuti manja anga apya chipherera ndi changu chake ndikutenga ndikupya manja ndikuponya mkamwa kukumba kweleka manja munthu mamaso kocha mkamwa ndi chimanga chobulisa chimene Malawi center imene ali lero.
Good morning, colleagues from the media. Once again, welcome to this press briefing. As you have heard from the briefing coordinator, this press briefing has been called by State House Malawi on instructions from His Excellency the President, Professor Peter Mutharika, to brief the nation through you, the media, on two main presidential decisions made recently, namely, 1, the decision of His Excellency the President, Professor Peter Mutharika, on the recommendation from the Public Affairs Committee of Parliament, PAC, for the President to remove commissioners of the Malawi Electoral Commission, MEC, for alleged incompetence. 2, the decision of His Excellency the President, Professor Peter Mutharika, to consider assenting to 4 bills passed by the National Assembly in February this year. I'll start with a briefing on the request to the President to assent to the 4 bills passed by Parliament in February. I'll give you the brief, which will have the decision and the reasons for the decision. A statement delivered on behalf of the State President of the Republic of Malawi, Professor Peter Mutharika, on action taken on the 4 bills passed by the National Assembly in February 2020. As Malawians are aware, under Section 48, subsection 1 of the Constitution of the Republic of Malawi, all legislative powers of the Republic are vested in Parliament. Section 49 of the Constitution describes Parliament as comprising the National Assembly and the President as head of state. An Act of Parliament is a bill which has A, been laid before the National Assembly, B, been passed in the National Assembly by a simple majority or such other majority as is otherwise required by the Constitution in respect of any particular bill, and C, has been assented to by the President in accordance with this chapter. Section 73 of the Constitution deals with the issue of presidential assent to bills. By Section 73, subsection 1, where a bill is presented to the President for assent, the President shall either assent or withhold assent, and shall do so within 21 days from the day the bill is presented to him or her. Section 73, subsection 2, states that where the President withholds assent to a bill, the bill shall be returned to the Speaker of the National Assembly by the President with a notification that the President's assent has been withheld, including reasons therefor. And the bill shall not be again debated by the National Assembly until after the expiry of 21 days from the day of notification of that withholding. Going by Section 73, subsection 3 of the Constitution, if the bill is debated again and passed by a majority of the National Assembly at any time between the date of expiry of the 21 days referred in subsection 2 and 3 months from that date, the bill shall again be presented for assent to the President. Under Section 73, subsection 4 of the Constitution, where a bill has been presented for assent in accordance with subsection 3, the President shall assent to the bill within 21 days of its presentation. When a bill has been duly passed and assented to in accordance with this Constitution, the Clerk of Parliament, shall cause it to be published immediately in the Gazette. Under cover of a memo from the Honorable the Speaker of the National Assembly dated 25th February 2020, the President's office duly received 4 bills that had been passed by the National Assembly for his assent consideration. The bills were as follows. A, the Electoral Commission Amendment Bill of 2020. B, the Electoral Commission Amendment Bill number 2 of 2020. C, the Parliamentary and Presidential Elections Amendment Bill of 2020. And D, the Parliamentary and Presidential Elections Amendment Bill number 2 of 2020. Having received the bills, the President is duty-bound to critically scrutinize each of the provisions in the bills and to grant his assent where it is desired. Most importantly, the President considers whether the provisions of the bills do not conflict with the provisions of the Constitution of the Republic, which is the supreme law of the land, or with other laws. The President pays particular attention to the fundamental or foundational principles of the Constitution, and most critically to the human rights provisions in the Constitution when considering whether or not to grant his assent to any bill. Assent will be withheld where the President perceives that any provision in the bill conflicts with the Constitution or other laws. And in any such case of withholding assent, the President is duty-bound to give his reasons to the Speaker of the National Assembly. With regard to the 4 bills discussed above, the general public is hereby notified that His Excellency the President, Professor Arthur Peter Mutharika, has withheld his assent to all the bills for the reasons that outline below. Reasons for withholding assent for Electoral Commission Amendment Bill 2020. In view of Section 8 of the Constitution, as read with Standing Order number 157 of the Standing Orders of the National Assembly, the proposed amendment to Section 4, subsection 1 of the Electoral Commission Act, as contained in Clause 2 of the bill, does not meet the test of constitutionality and lawfulness. B. The proposed amendment to Section 4, subsection 1 of the Electoral Commission Act, as is contained in Clause 2 of the bill, infringes the principle of separation of powers between various arms of government. C. In view of Section 12 of the Electoral Commission Act, which vests the power to appoint the Chief Elections Officer in the Commissioners, Clause 3 of the bill, whose effect is the termination of the employment of a specific Chief Elections Officer by Parliament, is unlawful and constitutionally unsound, as it is in conflict with the specific role of the legislature under Section 8 of the Constitution. The legislature is usurping powers of the commissioners, who are domiciled in the executive branch of government. D. In view of Section 13, subsection 3 of the Electoral Commission Act, Clause 3 of the bill, which seeks to second the Clerk of Parliament to the Commission, is unlawful in view of the lack of approval of the said secondment by the Commissioners. It is also an instance where the legislature is usurping the powers and functions of the Commissioners who are domiciled in the executive arm of government. E. Clause 4 of the bill, which seeks to amend Section 20 of the Electoral Commission Act by barring the Attorney General from acting for the Commission in litigation, infringes Section 98 of the Constitution. I now turn to reasons for withholding assent for the Electoral Commission Amendment 2. Clause 2 of the bill cannot lawfully and competently amend Section 4 of the purported, in quotes, Principal Act. That was never assented to by the President. B. Subjecting the appointment of the chairperson of the Commission to the Public Appointments Committee's recommendation, as is purported to be done through an amendment to Section 4 of the Electoral Commission Act introduced under Clause 2 of the bill. 1. Amounts to unreasonable use of public resources insofar as 2 public bodies, being the Judicial Service Commission and the Public Appointments Committee, will be engaged in the selection process. 2. It does conflict with Section 75 of the Constitution. 3. It does conflict with Section 8 of the Constitution, most especially the principle of separation of powers. 4. It does conflict with Standing Order number 157 of the Standing Orders of the National Assembly. C. Subjecting the appointment of other members of the Commission to the Public Appointments Committee before appointment, as it is purported to be done through an amendment to Section 4 of the Electoral Commission Act that is being introduced by Clause 2 of the bill. 1. Does conflict with Section 8 of the Constitution, most especially the principle of separation of powers. It does conflict with the Standing Order 157 of the Standing Orders of the National Assembly. D. The amendment to Section 13 of the Electoral Commission Act, that is sought to be brought under Clause 3 of the bill is not a competent and legitimate one in view of the fact that the principal act that is sought to be amended never received presidential assent. I now turn to reasons for withholding assent for the Parliamentary and Presidential Elections Amendment Bill 2020. A. The proposed amendment to Section 23 of the PPEA as contained in Clause 2 of the bill is in breach of the right to vote under Sections 40 subsection 3 and Section 77 of the Constitution insofar as it introduces a restrictive condition to the right to register as a voter. B. The proposed amendment to Section 23 of the PPEA contained in Clause 2 of the bill is unreasonable and constitutionally unjustifiable as a restriction or limitation to the right to vote under Section 44 of the Constitution, insofar as the same is not of general application but only applies with respect to the in-court fresh elections. C. The proposed amendment to introduce Section 29A in the PPEA contained in Clause 3 of the bill will have the effect of infringing the right to vote by way of preventing people from registering to vote, insofar as the Commission will now be able to introduce an abridged period for registration of voters in the fresh election, which abridged period does not take into account what a fresh election, which abridged period does not take into account that a fresh election is not dissimilar to a general election, as all voters, including those that have just come of age, have to register to vote. D. Statutory provisions relating to a runoff election, as are provided in Clause 5 of the bill, which seeks to amend Section 57 of the PPEA, ought to have been preceded by an amendment to Section 80 subsection 2 of the Constitution and Section 96 subsection 5 of the PPEA to provide for a proper meaning to those provisions of the Constitution and the PPEA, and to expressly introduce the element of runoff election. E. The amendment to Section 57 of the PPEA, as is proposed under Clause 5 of the bill, ought to make mention of the right to seek legal redress through the courts, and also make express mention that the Commission shall not announce a fresh election until after any or all candidates that would have challenged the results of the election through the courts would have exhausted all domestic remedies in relation to the challenge. I now turn to reasons for withholding assent for the Parliamentary and Presidential Elections Amendment Bill number 2 of 2020. Clause 2 of the bill, which seeks to amend Section 23 and 29A of the Principal Act, was incompetently and unlawfully introduced and passed by the National Assembly in view of the fact that the so-called in-court Principal Act was non-existent at the time, the same having not been assented to by the President at the time the bill was passed in the National Assembly. B. Following Sections 67 and 80 of the Constitution, it is not competent for the legislature to enact a statutory provision governing the timetable for a general election or a fresh election or a runoff election, as it did under Clause 3 of the bill. They can only do that in the Constitution. C. The material covered under Clause 2 of the bill and contained in the proposed amended Section 55A and 55B does not adequately cover all procedures and steps relating to a fresh election and a rerun. D. it was not legally competent for the National Assembly to enact Clause 4 of the bill that sought to amend materials in Section 57 of the In Court Principle Act relating to Section 80, subsection 2 of the Constitution, when the said material was not contained in any act properly so called. The bill that passed the amendment having never been assented to by the President at the time Clause 4 was being debated and passed by the National Assembly. The general public is therefore being notified accordingly. That's the briefing on the President's decision to withhold assent to the 4 bills that were passed by the National Assembly in February this year. I now turn to the second issue, the decision of His Excellency the President, Professor Arthur Peter Mutharika, to consider removing members of the Malawi Electoral Commission, the commissioners, on alleged incompetence. A statement on behalf of His Excellency Professor Arthur Peter Mutharika, President of the Republic of Malawi, on recommendations of the Public Appointments Committee, PAC, on the commissioners of the Electoral Commission. His Excellency the President, Professor Arthur Peter Mutharika, has read the report of the Public Appointments Committee that relates to the inquiry into the capacity and competence of the commissioners. The report discloses the following shortfalls that relate to the right to lawful and procedural fair administrative action under Section 43 of the Constitution. A. The letters of invitation to each commissioner to a hearing are not disclosed in the reports. B. The commissioners were apparently not given adequate time to prepare for the hearing. At law, there is need to give individuals adequate time to prepare to attend to inquiries. C. The report does not indicate whether any of the commissioners were given specific particulars of incompetence or incapacity in the letters inviting them to a hearing. At law, individuals are entitled to prior notice of all the charges that they will have to face at a hearing so that they prepare for the hearing adequately. D. The report does not disclose whether the commissioners were given the right to bring lawyers to represent them at the hearing. E. The report has failed to establish that members of the committee individually or collectively lack competence and capacity. F. The report does not factor in the role that other stakeholders played in agreeing with the commissioners on procedural issues and forms to be used, and puts the whole blame on the commissioners. Hence, its findings are questionable. Apparently, the Malawi Electoral Commission had the competence and capacity to manage the local and parliamentary elections, but lacked the competence and capacity to manage the presidential election. His Excellency the President finds this position specious and laughable. H. The committee could as well have been prejudiced by the findings of the Constitutional Court. And since the Constitutional Court judgment is under appeal, and in light of the above reasons, His Excellency the President, Professor Arthur Peter Mutharika, has not accepted the PAC Committee's recommendation to remove the MEC commissioners, including the chairperson. That's the end of the brief. I thank you so much.